Hello and welcome. I'm Peter Afrasiabi, host of The Curious Lawyer, and this Curious Lawyer program is on the 13th Amendment. It's part of our Civil War amendments series that we will be doing in The Curious Lawyer. Many of you may have seen our Bill of Rights series where we take each of the first 10 amendments to the Constitution and spend 1 hour with each of them so that you become the expert on each of those amendments, and when you're at your cocktail parties, you'll be able to tell people what the Third Amendment's about. This series is now focusing on the 13th Amendment, and this program today is on that. But real quick, just to give you a broader background about what we do here, is we take different legal issues. As you see here on our slide, we've had our Bill of Rights series, dog law, CIA law. What we do is take these issues that are of political, social, legal significance, and we funnel them through the legal prism to see how they intersect with the law. So this gives you educating, entertaining, fun CLE. It's low stress, it's off the beaten path to what you normally do, and it lets you get some insight into different areas of the law that you may not have otherwise been exposed to or seen. So for example, if you want to learn all there is to know about copyright and you happen to love the music of U2, you can do our program on U2 and copyright, where we have a playlist of multiple U2 songs and we use each of the songs to address various different issues within copyright law. So you leave knowing copyright law, but you've done it through the prism of U2. CIA law, dog law, and the fun, fascinating one is whether there's a place in the corner of Yellowstone National Park where you could murder someone and get away with it because it's free from the law. Don't kill anyone, but the answer to that question, though, you got to watch the program to find out. Let's get going today with an overview of what we will be looking at as we parachute in on the 13th Amendment. We're going to be talking today about what is slavery, what is involuntary servitude. We're going to look at the line between forced labor, physical coercion, and civic duties that sometimes actually require free labor. We're going to look at what the badges of slavery are. We're going to look at the 13th Amendment, Section 2, power of Congress to enact laws such as the Civil Rights Act, the Shepard-Byrd Act. We're going to look at whether you can sue a private person under the 13th Amendment if they enslave you. I mean, can you sue them for the 13th Amendment violation? Seems like you should be able to, right? We're going to find out. All along the way, we're going to look at landmark 13th Amendment decisions from the Supreme Court going back to right after the Civil War up until more modern times. And we'll have some fun modern twists on 13th Amendment in litigation. We're going to explore whether taxation is involuntary servitude. School-based mandatory community service, is that a violation of the 13th Amendment? And we're even going to look at Nevada's legal prostitution laws and structure and whether that's a facilitator of 13th Amendment violations in Nevada's brothels. Let's get going by starting where we should, with the text of the 13th Amendment. Section 1, neither slavery nor involuntary servitude except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Very simple words, right? Section 2, Congress shall have the power to enforce this article by appropriate legislation. So structurally, we have an affirmative constitutional amendment that basically bans slavery or involuntary servitude unless someone's being punished for a crime where they've been convicted, at which point, you may be engaged in involuntary servitude in the prison. We'll look at some of those cases too. And critically, the Section 2 power is that in order to enforce the idea that we're not going to be a nation that has slavery or involuntary servitude, Congress can start enacting laws and legislation to achieve these ends. That, of course, spawns litigation. But let's start in the beginning. So we've got the aftermath of the Civil War. You see here on our slide, Civil War aftermath. And the 13th Amendment's passed. It's sent for ratification to the states. It's ratified when Georgia became the 27th of the 36 states at the time who voted in favor of the amendment. And so Congress then starts passing laws. And it passes the Civil Rights Act of 1866, which is now codified at 42 U.S.C. 1981, and the basic provision is that all citizens of every race and color, without regard to previous servitude, fundamental rights, which are essence of civil freedom, the right to make and enforce contracts, to sue, to give evidence, to inherit, to purchase, to sell, is enjoyed by all, just as it's enjoyed by white. The Peonage Act was then later passed that says there cannot be forced work against will, even if someone's in debt, but it's specifically not applicable to convicted prisoners. We have the Civil Rights Act of 1875 that made it illegal to discriminate on the basis of former slave status, and public accommodations cannot refuse service due to race. This, of course, spawned a lot of litigation. And so we'll start by getting a little more specific and double-clicking, as you see on this slide here, in terms of the Civil Rights Act of 1875 and the actual language. And here's the language. All persons within the jurisdiction of the U.S. shall be entitled to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement, subject only to the conditions and limitations established by law and applicable alike to citizens of every race and color, regardless of any previous condition of servitude, and there's a $500 penalty for a violation. This brings us to our first set of cases we'll look at from the U.S. Supreme Court, which comes on the heels of the enactment of that legislation and the end of the Civil War, what are known as the Civil Rights cases from 1883. And so here's the basic fact pattern from a series of cases that were bundled up together and went to the Supreme Court. Here we have a conductor of a railroad refused to allow one Mrs. Robinson to ride in the ladies' car because she was a person of African descent. And she was with a young man the conductor thought was white, and he thought that there was some sort of improper connection between them. So wouldn't let her go. So she brings a lawsuit under the Civil Rights Act. The jury finds for the defendant. And the case goes on up to the Supreme Court. And the holding, the majority holding was that they took up the case on the issue of whether the civil rights statutes laws were actually constitutional. And what they said here is its effect is to declare that in all inns, public conveyances, and places of amusement, colored citizens, whether slaves or not, and people of other races, shall have the same accommodations and privileges as everywhere enjoyed by white people. And they held that the 14th and 15th Amendments didn't give Congress such power to enact the law. Quote, some obnoxious state law passed, or that might be passed, is necessary to be assumed in order to lay the foundation of any federal remedy in the case, and for the very sufficient reason that the constitutional prohibition is against state laws impairing the obligation of contracts. So the net result is that the 13th Amendment also didn't empower Congress to pass laws punishing these private acts of racism. So that's 1883. Now there was a dissent, as you see on our next slide here, from Justice Harlan. The 13th Amendment, it is conceded, did something more than to prohibit slavery as an institution. My brethren admit that it established and decreed universal civil freedom throughout the U.S. But did the freedom thus established involve nothing more than exemption from actual slavery? Was nothing more intended than to forbid one man from owning another as property? Was it the purpose of the nation simply to destroy the institution and then remit the race, therefore held in bondage to the several states for such protection in their civil rights, necessarily growing out of freedom as those states in their discretion may choose to provide, or not, as it turned out, right? Were the states against whose protest institution was destroyed to be left free, so far as the national interference was concerned? So we had a big dissent, but it was a dissent. And so that's where things stood in 1883, and we're going to intersect again in a moment with this. Let's just remind ourselves about the 13th Amendment, since we're talking about enacting legislation, focusing on Section 2, Congress trying to sort of prohibit slavery and involuntary servitude, the badges and incidents of slavery, through legislation that the Supreme Court already is striking down. Let's go to involuntary servitude more specifically. Now we're going to go a little further, 10 years later, 1897, goes up to the Supreme Court. This is a shipping case, Robertson versus Baldwin. And you've got sailors on a ship. The ship's name is Argo in California, and they basically desert. They'd signed employment contracts to work the ship, but they said, no, we're not working anymore, whatever reason, they desert, and the ship owners get the marshals to go arrest them under a federal law that required seamen to carry on their contracts and allowed them to be arrested, detained, and forced back on the ships if necessary. They said this is forced labor, violating the 13th Amendment, and that federal law that allowed them to be arrested, detained, and thrown back on the ship to work was unconstitutional. The issue then before the Supreme Court was whether the epithet involuntary attached to the word servitude continuously, such that it made illegal any service which becomes involuntary at any time during existence, Or does it attach only at the inception of the servitude and characterize it as unlawful because it was unlawfully entered into? So you can see that is the construction, the statutory or the amendment language construction the court was going through to figure out, are we even dealing with an involuntary servitude issue? And so as we see on the next slide here of Robinson versus Baldwin, what did the court hold? Well, it held the prohibition of slavery in the 13th Amendment is well known to have been adopted with reference to a state of affairs which had existed in states since the foundation of the government. The words involuntary service were said to have been intended to cover the system of Mexican peonage and the Chinese coolie trade, the practical operation of which might have been a revival of the institution of slavery under a different and less offensive name. But it's clear, however, that the amendment was not intended to introduce any novel doctrine with respect to certain descriptions of service which have always been treated as exceptional, such as military and naval enlistments. Well, the contracts of sailors, the Supreme Court here held, were actually unique, and the opinion goes back to the time of ancient Rome and cites ancient Roman history in terms of sailors occupying a unique place of losing freedoms and being able to be forcibly constricted. Absence without leaves also were not ended by the 13th Amendment the court held. And so as a result, what the court held is that federal law was not invalid. Those workers could be put back on the ship and sent to work. Now, here we have a dissent again by Justice Harlan that says a contract of any kind by which one person agrees to be the slave of another couldn't be respected in any court, nor can it be the foundation of any right for anyone. Involuntary servitude, no matter when it arises, if it not be the result of punishment for crime for which the party has been convicted, it's simply forbidden by the Constitution as slavery. So he had a very, very expansive interpretation of what is involuntary servitude. But again, he was in the dissent and he lost. So let's now pivot back to this issue we've been looking at about private acts of discrimination, because this gets us to the turn of the last century, 1906, with the seminal case that stood for most of the 20th century, and that's Hodges versus United States. And so basically what we have here is that a criminal law that had been enacted under the 13th Amendment was used to charge some defendants with criminal conduct in federal court. And they basically were charged with using violent means to compel laborers, simply because they were colored men and citizens of African descent, to quit their work and abandon the place at which they were performing labor in execution of their contract. All of this is a quote from the opinion, obviously. And that as a result of this sort of conspiracy of those acts, these laborers were hindered and prevented solely because of their race from being able to even engage in their contractual work. And so that sort of was the fact pattern that sort of led to this then criminal indictment for interfering with their ability to even hold jobs and work. And so the criminal statute, as the Supreme Court then held, was actually invalid. Because the 13th Amendment was supposed to stop actual slavery, the court held. And so here we have them saying the following: but that it was not the intent of the amendment to denounce every act done to an individual which was wrong if done to a free man, and yet justified in a condition of slavery, and to give authority to Congress to enforce such denunciation. And by the 13th, it forbade slavery or involuntary servitude anywhere within the limits of the land. Whether this was or was not wiser way to deal with the great problem is not a matter for courts to consider. It is for us to accept the decision which declined to constitute them wards of the nation or leave them in a condition of alienage where they would be subject to the jurisdiction of Congress that gave them citizenship, doubtless believing that thereby in the long run the best interests would be subserved, taking their chance with other states and citizens where they should make their homes. And so the result is then that contracts that had been entered that required labor were simply not subject to 13th Amendment-based regulation. Now we have a dissent again, Justice Harlan again, and what Justice Harlan now says in Hodges is, the nation has destroyed both slavery and involuntary servitude everywhere within the jurisdiction of the U.S. It's invested Congress with power by legislation to protect freedom, thus established against the badges and incidents of slavery as it once existed, as the disability to make valid contracts for services was an inseparable incident of the institution of slavery, which the 13th Amendment destroyed. And so what he says is, as a combination or conspiracy to prevent citizens of African descent solely because of their race from making and performing such contracts is thus in hostility to the rights and privileges that inhere in the freedom established by that amendment. And so it should be affirmed. And so basically, again, you see this fault line being exposed, that the dissent here, Harlan is saying that the 13th Amendment saw and understood that, one of the badges and institutes of slavery was sort of the idea that you can enter sort of these contracts that the law will sanction and protect that functionally make people slaves or involuntary servitude victims, and that when interference is being made by people with other people's right to work in some way, federal legislation punishing that as a federal criminal civil rights-based violation should be affirmed. But again, he was in the dissent. So where this brings us now is to the question of forced labor in 1911. And this is in distinction. We're still talking about involuntary servitude, but now we're talking about forced labor. And you see here Bailey versus Alabama. And the basic contract is this, the basic facts are as follows. Bailey is contracted to work on a farm. He's going to be paid $12 a month, and he worked for a month or so, and then he quit. And he had been given a $15 advance, and he didn't return the advance. So he works for a month, he gets the $12, he keeps his $15 advance, he takes off. And the Alabama substantive law at the time said that Bailey's act was prima facie evidence of a crime of intending to defraud an employer. Alabama law substantively also didn't allow one to testify as to their uncommunicated motives or intentions as to why they took the money and quit. And so basically, those structures within Alabama law meant that he's not able to explain what his true motive or intent was. And the law says that if you take money and then quit employment, it's prima facie evidence that you intended to defraud. And criminal law says if you intend to defraud, you go to jail. So you kind of have a conviction, out of the gate, teed up and guaranteed almost. And so he was convicted, sentenced to 136 days of hard labor under this peonage law, and he challenged it under these federal anti-peonage laws that had been passed after the enaction of the 13th Amendment. This time the Supreme Court holds as follows. And you have it at the bottom here. The plain intention was to abolish slavery of whatever name and form and all its badges and incidents, to render impossible any state of bondage, to make labor free by prohibiting that control by which the personal service of one man is disposed of or coerced for another's benefit, which is the essence of involuntary servitude. While the amendment was self-executing so far as its terms were applicable to any existing condition, Congress was authorized to secure its complete enforcement by appropriate legislation. And so what that means is that this time they held that this set of Alabama laws that allowed someone to go to jail because they were presumptively engaged in this crime was unconstitutional. And so the case got sent back, and those laws were struck as being in violation of the anti-peonage laws, and fundamentally as sort of being, the state of Alabama system created involuntary servitude setup and system such that people had no choice but to stay and work, and couldn't even explain why they left and quit as sort of the defense to fraud. But as you see on our next slide here, we have a dissent again. This time it's only a dissent, but it's Justice Holmes. His position is as follows. Breach of a legal contract without excuse is wrong conduct, even if it's for labor. And if a state adds to civil liability a criminal liability to fine, it simply intensifies the legal motive for doing right. It does not make the laborer a slave, nor does it matter if labor is added to the imprisonment. Imprisonment with hard labor is not stricken from the statute books. On the contrary, involuntary servitude as a punishment for crimes is accepted from the 13th Amendment. If work in a jail is not condemned in itself without regard to what the conduct is it punishes, it may be made a consequence of any conduct that the state has the power to punish at all. And so what Holmes is saying is basically that the state has the right to outlaw fraud, and it has the right to criminalize fraud. And if it chooses to criminalize fraud by sending you to jail, then it can do that. And if it does that, and then you got to work along the way while you're in jail, 136 days of hard labor, so be it. And so this is a dissent, though, and he does not win the day. And now, since we've been talking about the peonage laws, we're going to pivot and shift here to a little more specificity on those laws. And we're going to look at the case you see on our slide here of United States versus Reynolds. This is at 235 U.S. 133 from 1914. And so let's talk about just factually what it said and functionally what peonage is. Peonage is a condition of compulsory service based upon the indebtedness of the peon to the master. The basal fact is indebtedness. Congress enacted a law under the 13th Amendment to abolish it and punish peonage. So that comes out of the case, and that's just sort of our background in terms of what is peonage. So let's look at the actual facts here. We have, in 1910, a convict named Rivers enters a contract with Reynolds to work as a farmhand for 9 months and 24 days. He's going to get paid a certain dollars per month. And he was then indicted, or the indictment charged, in other words, that he entered into the service of Reynolds and under threats of arrest and imprisonment if he ceased to perform such work and labor. He worked until the 6th day of June when he refused to labor. So basically, he was threatened and forced to work, and in the structure, and he had no choice. And so a criminal indictment then comes down on the guy for doing that. And so what they say is, applying this definition to the facts here shown, this is the issue, we must determine whether the convict was in reality working for a debt for which he owed the surety, or whether the labor was performed under such coercion as to become a compulsory service. And what did they hold? The surety may cause the arrest of the convict for violation of his labor contract. He may be sentenced and punished for this new offense and undertake to liquidate the penalty by a new contract of a similar nature. And if again broken, it may be prosecuted again. And the convict is thus kept chained to an ever-turning wheel of servitude to discharge the obligation which he has incurred to his surety, who has entered into an undertaking with the state or paid money on his behalf. The law was then held valid. Let's now pivot, and we're going to see, so we see conflicting peonage type structures and approaches as to the struggle that was coming out in terms of the legal art landscape that was being created on those contracts. But now we're going to pivot to the draft, and we're going to look at the issue of, is a draft a violation of the 13th Amendment? This brings us to Arver versus United States, 245 U.S. 366 in 1918, and the 30,000-foot view of what's going on here is that the 1917 law was passed that allowed a draft for World War I. And basically, not enough people had voluntarily signed up to go join World War I when President Wilson had announced that we were going to be entering the war. And so they passed a law to sort of create a draft to get more soldiers to send off to Europe. Now, a bunch of people refused to be drafted, and they were prosecuted for it. And they challenged the draft law as being unconstitutional under both the 13th and the First Amendments. And so here is a quote from the court that kind of sets up where the court may be going. It may not be doubted that the very conception of a just government and its duty to the citizen includes the reciprocal obligation of the citizen to render military service in case of need and the right to compel it. So you can imagine where the court's going to come out after holding that. What it held as to the 13th Amendment, and this is literally the quote, as we are unable to conceive upon what theory the exaction by government from the citizen of the performance of his supreme and noble duty of contributing to the defense of the rights and honor of the nation as the result of a war declared by the great representative body of the people can be said to be imposition of involuntary servitude in violation of the 13th Amendment, we're constrained to the conclusion that the contention of that effect is refuted by its mere statement. In other words, even the argument that it's a violation of the 13th Amendment is borderline nonsensical. Citizens have a duty to, reciprocal duty to the government, in other words, as I said, of military service, and that's not a violation of the 13th Amendment. As to the First Amendment, just as an interesting aside, they noted, without anything but statement that the proposition that an establishment of a religion or interference with the free exercise thereof is repugnant to the First Amendment resulted from the exemption clauses of the act to which we at the outset referred, because we think its unsoundness is too apparent to require us to do more. So in other words, the First Amendment claim was so frivolous, we don't need to say anything else other than it's nonsensical. So we all could be drafted. Of course, there was a draft in the 1960s. And it could happen again, and there is no 13th Amendment right to escape the draft. But what about strike breaking? This brings us, as we traverse through the 20th century, we are now up to the 1940s, and we're going to look at the case of UAW versus Wisconsin Employment Relations Board, 336 U.S. 245. We're in 1949 now, and we're going to look at strike breaking. So here are the facts. The collective bargaining negotiations broke down. There's a deadlock. And so basically, in order to bring pressure on the employer, the union adopted a plan. And basically they said, we're going to hold union meetings at irregular times during work hours. We're not going to give advance notice to the employer as to whether or when the employees would return. And basically what this means is that they were interfering with the work being done in work hours because they said, well, we have to hold union meetings and we don't know how long they're going to take. And they would just happen when they chose to have it happen, right? Sort of a strike. Well, this goes to the Employment Relations Board that issues an order forbidding the individual defendants and the members of the union from engaging in this effort to interfere with the production by those methods. So what did the striking auto workers and union do? They challenged this and they said this violates the 13th Amendment because you're imposing forced servitude by not letting us strike when we want to strike. What did the Supreme Court hold? Nothing in the statute or the order makes it a crime to abandon work individually or collectively, nor does either undertake to prohibit or restrict any employee from leaving the service of the employer, either for reason or without reason, either with or without notice. The facts afford no foundation for the contention that any action of the state has the purpose or effect of imposing any form of involuntary servitude. And so what that means is that at that point, the UAW had been stuck in the situation of being told it's not involuntary servitude. You're not being forced to work. You can quit work if you want. Your people can quit and not go back to work, but you don't get to do this whenever you want in that manner, and the Employment Relations Board can actually enjoin it. So that kind of strike breaking that went on and said, you don't get to sort of hold these meetings in that way was not a violation of the 13th Amendment. Let's talk about forced labor a little bit more, though, and we're going to go to now the 1980s, and we're going to take the case of United States versus Kominsky. And this is sort of a foundational case for the law in terms of what's routinely cited up until today now. And this comes from 1988, 487 U.S. 931. And basically, two mentally retarded men were found laboring on a farm in poor health. They were in horrendous conditions, isolated from the rest of society. The facts were nasty if you read the opinion. But basically, then the people running this farm with these forced, these poor folks being forced to work in this way are charged under federal criminal laws for conspiring to prevent them from exercising their rights to be free from involuntary servitude. What basically happens is that they are found guilty. They then challenge this on the basis that they did not use physical coercion. And the law, to be valid under the 13th Amendment, requires some sort of physical coercion. In other words, their argument was, look, we didn't physically restrain them. They could have walked off the farm anytime they wanted. And if that being the case, we didn't go to court and use a legal, set of legal laws or whatnot to force them to work. And so, whatever we did may have been morally horrendous, took advantage of people who didn't have their wits about them and the like. But their position was that for legislation to be valid under the 13th Amendment, there's got to be some level of physical coercion to reach the level of the badges and incidents of slavery and involuntary servitude. That's their argument. What did the Supreme Court hold? Well, the Supreme Court rejected the government's broad construction of involuntary servitude that would prohibit the compulsion of services by any type of speech or intentional conduct looked at from the victim's point of view that leaves the victim with no tolerable alternative but to serve the defendant, or they perhaps lose their power of choice. So the government went in and said, no, it doesn't have to be physical coercion. If you do anything that makes someone just feel nervous, uncomfortable, they don't really have an alternative, and they feel stuck or whatnot, that can be enough factually under the statute to be viable. And so the Supreme Court said, no, that's too much. You've gone too far there. The Congress can't have intended that if I yell and scream at someone to stay at their desk and finish their work and they're too scared to leave and they stay, that I've now tripped the 13th Amendment. And the jury instructions did allow that breadth of sort of wrongdoing. And so what the Supreme Court said is the jury instructions were wrong in that sense. And so the criminal convictions were reversed. But what the Supreme Court said, there was plenty of evidence in the record here that showed actual kind of physical coercion and would be the type of morally reprehensible that they should be punished as crimes. And so, they weren't going to just outright reverse and acquit them. They said because enough evidence of physical coercion existed, the case should be remanded for a new trial, but just with better jury instructions that didn't go too far and have too much breadth. And so that fault line, in terms of the level and scope of coercion, is a very, very important fault line in 13th Amendment law today. So now let's bounce into the 21st century, and we're going to go to the Ninth Circuit, and we're going to look at involuntary servitude in the context of where we have forced labor intersecting with immigration. And this case is called United States versus Virapol. It's reported at 312 F3rd 1128. It's from the Ninth Circuit in 2002. And the basic facts are as follows. The defendant who's been indicted here was, by common law, married to the Thai ambassador. And so as a result, this person was getting Thai nationals visas so that they could come to the US and work in her restaurant. And she made them work brutally long hours, excessive hours. She refused to let them leave, refused to let them speak to customers or use the phone. And so she was then indicted of holding people, criminally indicted, of holding people in the condition of involuntary servitude under the federal Civil Rights Act laws. This was Section 1584. She's convicted. And that's a 13th Amendment statute passed by Congress under its Section 2 power. And so the jury was instructed, per the Kosminski's case that we just looked at, to assess whether the physical coercion and threats could plausibly have compelled the victims to serve. And what the defendant here argued is that the 13th Amendment would require, or what they argued is that there had to be some instruction on a minimal level of threats beyond plausible compulsion. And here's what the Ninth Circuit held. Threatening an immigrant with deportation could constitute the threat of legal coercion that induces involuntary servitude, even though such a threat made to an adult citizen of normal intelligence would be too plausible to produce involuntary servitude. Thus, the jury does not have to be instructed on a specific quantum of coercion force. This is a very important holding because what it makes very clear is that now we have threats of deportation, which isn't sort of like physical coercion in the traditional, like I'm going to beat you up kind of physical sense, but it's physical coercion, I guess, in the sense of you will be physically removed from the country, I'm going to have you deported. Those types of threats, even if you tell that to the average person, they're just like, whatever, I'm not going to work for you because of that. To an immigrant in these situations, that can be enough. And so no, the jury didn't have to be instructed on a different set. And that would be an example then of a legitimate involuntary servitude fact pattern and statute enacted under the 13th Amendment. Let's now get to that question that all of your kids are asking you when to graduate high school, they have to do a certain amount of pro bono community service work. Is it a violation of the 13th Amendment laws on prohibiting involuntary servitude? Turns out the case has been litigated. This is the case of Steyer versus Bethlehem Area School District. It's reported at 987 F2nd 989. It comes out of the Third Circuit in 1993. And so here's a basic fact pattern. High school students and their parents sued a bunch of school officials, and they complained that the mandatory service program that was a graduation requirement violated their 13th Amendment protected rights against involuntary servitude. And so the basic rule of law adopted by the court was that involuntary servitude is based on physical or legal punishments if the service is not done. But civic duties, such as jury duty and military service, may be imposed subject to a legal punishment. Thus, the syllogism goes, involuntary servitude is not all forced labor. It must be a situation truly, quote, akin to African slavery, end quote. And that's sort of the line that the court has created. And so this is an important line when we think about this line between coercion by use of the legal system, to which you can have a legal punishment, which normally, if where you're being forced to work, which in the context of sort of commercial labor transactions, those types of legal punishments that may come from the legal system or physical coercion, that is involuntary servitude. But there's a whole range of civic duties, things that are defined as being civic duties that can have legal consequences that follow if you refuse to participate, such as jury duty, the draft, and the like. Those are okay, even though they're in some technical sense forced labor. That's not the kind of forced labor that the 13th Amendment is concerned with. So what did the court hold? An educational requirement does not become involuntary servitude merely because one of the stated objectives of the program is that the students will work, quote, without receiving pay, end quote. Accordingly, we hold that the mandatory community service program instituted in the Bethlehem Area School District as a high school graduation requirement does not constitute involuntary servitude prohibited by the 13th Amendment. So when your kids come home and say, I was learning in government class about the 13th Amendment and the Civil War, and I don't like having to do this mandatory school community service, you now actually have a legal doctrine to tell them why it's not involuntary servitude, even though at first blush, maybe it feels like it kind of is. This is an important civic duty line. What about income tax? Well, let's be honest. We all know that income tax does not violate the 13th Amendment's prohibition on involuntary servitude because we're all filling out tax returns every year. And if it was a violation of the 13th Amendment, we would have known many years ago and would all have a lot more money in our bank account. But let's just take a quick look at some of this stuff. We have Casey versus Commissioner. And this is sort of the basic sort of idea coming out of the Ninth Circuit in 1972 that held it's meritless to even functionally make the argument that keeping records and filing tax returns is infringing upon involuntary servitude prohibitions of the 13th Amendment, or even there, also the Fifth Amendment privilege against self-incrimination. It's essentially frivolous. And that's basically the same rule that comes from all the different circuit courts. You see I've got a list of other cases here for you from other circuits. We have Ginter versus Southern. This is 611 F. 2nd 1226 from the 8th Circuit in 1979. It held the same. We have Porth v. Broderick, 214 F. 2nd 925 in the 10th Circuit. The same, it's frivolous. We've got a more recent bankruptcy court case here and a quote from it for you. This is Wilbert versus IRS at 262 BR 571. This is a bankruptcy court. The long and the short of it is, as you can see, income tax requirements, in other words, we must work and give away some of our labor or the yieldings from that labor to the government, are not a violation of the 13th Amendment. What about prison labor? This brings us to the next slide. And have there been any, chinks in the armor, so to speak, as sort of the people chiseling away at sort of that basic rule that comes out of the text of the 13th Amendment that accepted from involuntary servitude, service and labor in prisons? Well, there was a minor one that popped up in 1990, and you see this case here of Watson v. Graves, and this is coming out of the Fifth Circuit, 909 F. 2nd 1549. And it made in passing reference the idea that actually prisoners may have some 13th Amendment rights in the context of involuntary servitude, that there are limits. Now that was in 1990 from the Fifth Circuit. And about 10 years later, the Fifth Circuit, you see here in Alley versus Johnson, took that issue up and said, no. And so here we have the case. It's reported at 259 F. 3rd 317, the Fifth Circuit 2001. And it reiterated that inmates sentenced to incarcerations cannot state a viable 13th Amendment claim if the prison system requires them to work. Period, full stop, end of story. And what it noted is that Watson case, that was an anomaly and it lacks any authority whatsoever. In other words, it essentially abandoned whatever Watson was starting to try to say in passing reference that, well, maybe it's not that broad. No, it's that broad. So this, of course, then brings us to some other circuits we can wander through. We have Ray v. Mabry, 556 F. 2nd 881. This is coming out of the 8th Circuit in 1977, and it said, the 13th Amendment allows people to force prisoners to work, and if they got to work 120 hours a week, they got to work 120 hours a week. That's okay. not a violation of the 13th Amendment. Loving v. Johnson, this comes out of the Fifth Circuit in 2006. This time they go even further and they make clear that not only can you be forced to work, there's not even a right to be paid any amount of money, even if it's the de minimis, 10 cents an hour or whatever it is, for labor while in prison. In other words, there's a total blanket exemption from the 13th Amendment's involuntary servitude prohibitions when it comes to convicted folks in prison. We also have here's a state case, Oklahoma 1985 from the Oklahoma Supreme Court, Cumbry versus State. It's reported at 669 p. 2nd, 1094. And this one upheld the conditions that inmates even have to pay part of their wages to an inmate trust savings account. So what you basically had there is that they were paid, but then forcibly required to take some of that money they earned to be put into a trust savings account. When that was challenged, nothing that could be done there. It was not a takings, and it was not a violation of the 13th Amendment. And then on top of that, you've got Sigler versus Lowry. This is another Eighth Circuit case reported at 404 F. 2nd, 659. And here you have the ruling that when prisoner pay is given, the state can make them work. It can give them a small amount of pay, but it can also then take that pay to reimburse the state for state expenses. And finally, you've got, this is sort of a Pennsylvania court case, 133 A. 3rd 350 is where it's reported. It's Commonwealth Department of Corrections versus Tate. And this one makes clear that, at least in Pennsylvania, as it looks at these issues and challenges being brought pursuant to the 13th Amendment, prisoner pay is not even considered wages, period. It's simply a gratuitous payment of money, and it's seen as a rehabilitative tool, not wages. And so that fault line there is just another explanation for how there's an absolute wall of authority that prison labor in the 21st century still, long hours, hard working conditions, minimal pay, having the money taken to reimburse for state expenses, having the money put into some trust savings account, whatever, all okay. None of them are violations of the 13th Amendment. But is there a private right of action against private parties under the 13th Amendment? Let's pause and talk about that on this next slide, because that's an important question. For example, if I enslave you and lock you up and enslave you, can you then, when you escape, sue me, Peter, and say, I'm filing a complaint and I'm suing you under the 13th Amendment? You violated the 13th Amendment, Peter. Well, the answer is no court has actually ever directly upheld a direct right of action against a private party under the 13th Amendment. Now, you'll find many courts that have assumed such a right may exist, but they proceed to deny on the merits anyway. And that's important because, assuming it but denying on the merits doesn't get to the answer of whether there is one. So let's take a look at a prototypical case. This comes out of the Southern District of California in 1997, Elmer versus Metzger, and it's reported at 967 F. Sup. 398. And here's the quote from page 402 of the opinion. Plaintiff has pointed to no authority, and the court knows of none, allowing a plaintiff to proceed directly under the 13th Amendment against private parties such as the defendants here. This case only involves alleged private wrongdoing. State law has traditionally addressed such torts as false imprisonment, intentional infliction of emotional distress, assault and battery. These traditional state causes of action appear to redress the plaintiff's injuries adequately in this case. We also can go look at a case from Rhode Island. This is Turner versus the Unification Church, reported at 473 F. Sup. 367. This is from 1978, where plaintiff Turner sued the Unification Church under the 13th Amendment. And here again, the court held, private claims sounding in the 13th Amendment have remedies under state laws, so there is no private right of action. And so this is the general rule that has developed, even though the direct question hasn't made its way up to the Supreme Court of the United States. The rule that's developed is if a private person enslaves another private person, as between the two in terms of suing them and seeking a private remedy, you don't get to sue under the 13th Amendment because there's adequate state tort remedies. You sue for false imprisonment, you sue me for intentional infliction of emotional distress. There's all manner of state claims that give you the redress for that forced involuntary servitude of slavery as between purely private people when you want a private remedy. Now, of course, if I enslave you, I can be criminally indicted under federal laws enacted pursuant to the 13th Amendment, and those are, of course, legitimate exercises of the Section 2 power, or perhaps even the Commerce Clause power, as we will see in some of these cases. Let's go back to this act, though, of this question that we talked about in the beginning, private acts of discrimination, where, the scope of those federal statutes in terms of allowing federal criminal prosecutions against private discrimination were limited back at the early part of the 20th century, as you remember in that case. Let's look at what's happened as we got later into the 20th century, into the civil rights era of the 1960s. And this is Heart of Atlanta Motel versus United States, 379 U.S. 241, 1964. So, we now have the Civil Rights Act of 1964 that had been enacted, and it was enacted pursuant to both the Commerce Clause power of Congress, but also the 13th Amendment Section 2 powers. And what it prohibited was race discrimination in public places. And so what we had here is a situation of a hotel refused to rent to Black Americans. And it said that, we don't want to do that. That's our right. We're a hotel. It's private property. We're not going to, rent hotel rooms to you. And the hotel owner actually sued for a declaration that the Civil Rights Act was invalid. And they said it was invalid under the Commerce Clause power, and also that by forcing it to rent rooms to people it didn't want to, it was subjecting it to involuntary servitude under the 13th Amendment. And so the question is, was this statute passed by Congress in 1964 a legitimate exercise of Commerce Clause power, number one? And number two, did it somehow violate the owners of the hotel, their 13th Amendment rights? Well, here's what the Supreme Court held, 9-0. Hotels are part of commerce. It is said that the operation of the motel here is of a purely local character, but even assuming this to be true, if it is interstate commerce that feels the pinch, it does not matter how local the operation which applies the squeeze. That Congress was legislating against moral wrongs in many of these areas rendered its enactments no less valid. Thus, the power of Congress to promote interstate commerce also includes the power to regulate the local incidents thereof, including local activities in both the states of origin and destination, which might have a substantial and harmful impact upon that commerce. That, of course, is the broad conception of commerce that we understand in terms of the world we live in today. And so it was a legitimate exercise of the Commerce Clause power to deny people the right to, engage in race discrimination and renting out hotel rooms, even if it was truly a local hotel, which itself was even factually unclear. It was a hotel on like some interstate highway or whatnot. But as they noted, even if, it's okay. Now let's turn to the 13th Amendment claim. Remember, the hotel owners said, look, forcing us to rent hotel rooms to people we don't want is a form of involuntary servitude, making us work in a way we don't want to work. Here's what the Supreme Court said. We find no merit in the remainder of appellant's contentions, including that of involuntary servitude. As we have seen, states prohibit racial discrimination in public accommodation. These laws but codify the common law innkeeper rule, which long predated the 13th Amendment. It is difficult to believe that the amendment was intended to abrogate this principle. So, in other words, no way, no how, we can allow federal criminal or federal legislation that prohibits you engaging in private race discrimination, and those laws are valid. They enable people to bring civil lawsuits, and they enable the government to bring criminal lawsuits under the enacting legislation, as long as it's within the scope of the enacting legislation, in distinction to just suing under the 13th Amendment. So, this brings us, that happened in 1964, which means we're now seeing federal legislation prohibiting private race discrimination, allowing civil remedies to be brought by and between, for example, hotel operators and hotel potential guests, which of course means, are we going to revisit Hodges from that case we talked about the turn of the last century that was sort of the death knell of allowing Congress to legislate against private acts of discrimination? This brings us to 1968, Jones versus Alfred Mayer, 392 U.S. 409. This ultimately is a 7-2 decision, but let's look at the facts first. We have a real estate company that refused to sell a home to a black man. And so the company was sued for violating the Civil Rights Act. So he brings a private action saying, you're in violation of the federal civil rights statutes, the ones enacted way back when, and the new ones too, of course, the 64 Act and the later acts. And these acts provided that people shall have the same right in every state and territory as enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. Long statute that had been on books. Now, the suit was dismissed on the basis that the 13th Amendment law is really only for state action. It doesn't allow private action and private litigation like this. That, of course, goes back to what we were talking about earlier. And that's the Hodges case. But it comes up to the Supreme Court, and here's what the Supreme Court holds 7-2. Because the 13th Amendment is not merely a prohibition of state laws establishing or upholding slavery, but an absolute declaration that slavery or involuntary servitude shall not exist in any part of the United States, the power vested in Congress to enforce the article by appropriate legislation includes the power to enact laws operating upon the acts of individuals, whether sanctioned by state legislation or not. And so Hodges was fully overruled. Now, there was a dissent. Here's what the dissent argued. The only intent was for prohibition against state action that denied rights. It was not an affirmative grant to Congress to regulate private behavior, that negative-positive distinction. And so, quote, the Supreme Court in dissent said, "It seems to me that most of these men would have regarded it as a great intrusion on individual liberty for the government to take from a man the power to refuse for personal reasons to enter into a purely private transaction involving the disposition of property, albeit those personal reasons might reflect racial bias." And so basically what the dissent says is they think when Congress or when the states ratified the 13th Amendment and then it was enacted with, enacting legislation by Congress at the time, that they never would have imagined that the legislators of that era, I guess the founding fathers is probably not the right phrase, but that era's founding fathers, so to speak, would have ever regarded that what they were doing was, allowing one to legislate against even, horrible, private racial transactions in business. If, someone doesn't want to sell their home, they don't want to sell their home, nothing you, Congress, can do. And that was the dissent. And so this is 1968 where we still have that sort of construction and conception at play by the dissent. But the dissent was the dissent, the majority won, and so that means these laws that had been allowed by Hodges for, and Hodges, since the Civil War, and then Hodges was 1906, we're now talking a near century, finally came to an end in 1968, which gives birth to our real modern era. What about, let's pivot here to sex trafficking in the 21st century, and how does the 13th Amendment play out? Well, this is a Nevada case. You can see the citation up there at the top. It's from July of 2022. But basically, the fact pattern is this. Plaintiffs sue under the 13th Amendment and also under trafficking victim laws from Nevada. And they basically sued and said that state-authorized brothels had created a system of sex trafficking, of being put into brothels and then subjected to involuntary servitude. And so they sued the brothels, and they also sued Clark County for this legal regime that induced and facilitated what were alleged to be sex trafficking violations under the 13th Amendment. Well, as to the county, what the court held is that plaintiffs do not plausibly allege the injuries they suffered are really traceable to Nevada's legal system of prostitution. They simply allege that legal prostitution correlates with high increases in illegal trade of people. But what the court said is a state can have a legally sanctioned system of prostitution, and it's at best attenuated to plaintiffs' injuries where they claim as a result of that legal regime, trafficking is going on. So the county doesn't get to be sued for this stuff. As to the brothels, the 13th Amendment has no private right of action, and so suing them for violating the 13th Amendment can't stand. And so it's got to rest upon some other act of Congress or some state law or some such thing. What they held here is that the plaintiffs have not sufficiently alleged a nexus between the governmental and private defendants such that the challenged conduct of sex trafficking can barely be fairly attributable to the state. While state entities license and regulate prostitution in Nevada, this conduct does not amount to pervasive entwinement to the point of largely overlapping identity. So those claims were gone. But the private statutory tracking claims against the private individual defendants, those certainly survived to be litigated, to be assessed as to whether the brothels were engaged in state and or federal statutory torts involving trafficking. Well, this brings us today to our conclusions as we've walked through the 13th Amendment in this Curious Lawyer program. I hope you watch our 14th and 15th Amendment programs also, and of course go back to the Bill of Rights and watch all 10. But let's talk real quick about some of the conclusions that we learned today. We saw the enactment of the 13th Amendment coming out of the Civil War, banning slavery and involuntary servitude in no uncertain terms, and also in giving a Section 2 power to Congress related to the badges and incidents of slavery, basically, that had been, this power existed for Congress to enact laws to regulate and address people engaged in the business of slavery or involuntary servitude. Now, what we saw is that Section 2 power of Congress, as it at least related to allowing private person versus private person lawsuits, really lay dormant for many years. And we also saw in those early years after the Civil War a disparity of case law in terms of these involuntary servitude scenarios. We saw state legal systems, even early on, that created sort of genuine peonage type situations where you could be jailed for forced work. Those were invalid, even under the early Supreme Court decisions after the Civil War. But we also saw other decisions and cases where people were interfering, for example, and denying people the ability to even work because of the interference. That could lead to legitimate criminal prosecutions also. But we also saw, for example, that, striking workers, in their situation, you can't force striking workers to work. We saw those under threat of, criminal punishment. And we saw striking workers, however, experiencing, the idea that, ancient seaman laws allowed them to be put to work, and so they can be, forced to get back on, on the ship and work, so to speak, but not under threat of criminal prosecution. Now, we saw prison labor too that we looked at, and we looked at the whole panoply of things. But the basic rule that we conclude is that limited or no wages are okay. That's all there is to it. We also saw the interesting cases of drafts and income tax and mandatory community service. These are incidents of public civic duties, and they are accepted from the 13th Amendment's prohibition on involuntary servitude. And this brings us back to the reach of private conduct and really the ability of Congress to legislate against acts of private racial discrimination and hostility. And that ability has been broad given the 1960s reinterpretation of the old federal statutes that had been left dormant because of those early decisions shutting them down. And so those implementing laws and new implementing laws with a broad reach are all valid exercises of Congress's Section 2, 13th Amendment power, if not the Commerce Clause power. But remember, there is actually no self-executing right to sue a private actor directly under the 13th Amendment. I mean, when you are subjected to involuntary servitude and or slavery, and if it's you that wants to sue someone to get your financial remedy, you need to be suing under an actual enacted law that gives you, that's where the private right of action comes, because the amendment is not actually self-executing. But of course, for it's self-executing as to the state if they engage in it, automatically per se. But if you want to bring a case yourself against a private person, you got to find the state law. And if the government wants to bring a claim against someone for their mistreat of another private citizen, that's pursuant to the broad Section 2 power of the 13th Amendment. I hope you've enjoyed today's Curious Lawyer program. As ever, if you have questions, please feel free to email me. I love engaging with you on these topics. And of course, check out the other Curious Lawyer programs. Thank you.